A will is a court document that governs the probate process. So probate is this administrative process where if I die, my stuff has to get divided up. So someone has to be able to sell my house, someone has to be able to pay my bills, someone has to actually be appointed to do the stuff that's in my will. If we don't have a will document, we're still going to go through this probate process, this court process, but we're going to use the default rules, which I had no say in. It's what the legislature decides is going to happen. We don't want to do that. We don't want to do the defaults. We want to use my rules. We want to use your rules. And because of that, we want to get a will created. Probate has three things you always want to keep in mind. The first one is that it can take some time. Every probate is different. Right now, we're seeing probates take 8 to 9 months. Just to sell the family home. They are public in nature. So if I have a will document and this will document says, hey, give the money to my kids or hold on to it until they're a certain age, I don't know that my neighbors are that nosy, but for the record, if there's any sensitivity about that, that document's going through the public court system, and for some folks, there's some sensitivity there. And then probate does certainly have an expense. So if we're creating a will document, it's the cost of the will, and then if something happens to me, we're going to submit that will to the court system, and now we have that expense. It's a court hearing. It usually uses a lawyer. Can be anywhere. We tell folks to be ready for a $10,000 probate. Hopefully it's closer to $5,000, but the point is, there are some drawbacks to probate. What a will is going to do is it's going to control that process, but sometimes we don't want to go through that process. So what we're going to do instead is, instead of my assets purposely being sent to the court system, which is what a will does, I'm going to proactively and purposely steer it away from the court system and into our private family entity. It's called a trust. And this is the revocable trust. What this is, I like to think of this as being like a shoebox or something, and I'm going to take that house. I'm going to make sure it goes here. I'm going to take my bank account, and I'm going to make sure it goes here. I'm going to take, maybe if I have life insurance, instead of naming my spouse as getting the life insurance, maybe I'll name the Philip and Mary Ruce Trust if we had one of these. And anything that ends up going into this thing is not going to go to court. It's going to be controlled by our private family agreement, our trust agreement. A revocable trust is able to control things that end up in the family entity without going to court. It is a will replacement. We do it because wills go through probate, and for whatever reason, we feel this added peace of mind knowing we can just handle this around the kitchen table. The question of whether a will or a trust is better is really going to depend on the client. It's not that one is inherently better or worse than the other. What are the priorities? There are families we hear where they don't have a lot of assets and they feel strongly that the probate is going to be so simple it doesn't matter. Sometimes trusts can be pricey to set up, and depending on what someone's priorities are, they don't care about probate enough. And if you don't care about probate, well, go to probate. I think it's not the end of the world. Lots of families go through probate. For many families, they have a priority where they want their estate to be easy to administer. They want it to be fast to administer. The whole reason they're talking to an attorney is they're trying to make this process organized and easy. And for them, they are very frequently going to benefit from avoiding probate and using another tool. The most common that we see is certainly a revocable trust. Oftentimes, we're contacted because someone wants us to do a basic will. And my sort of funny answer to that is I don't know that I've ever seen a basic will, because they're all so different, and every family is different and every priority is different, and you don't really see two families who are exactly the same. Because of that, I don't know that I would say we do basic wills. We do wills that are fairly straightforward, of course, but it all depends on the family. A will can do so many things. Sometimes it's just about appointing the right person to be in charge. This is your personal representative. Some people call this your executor. We want to make sure there's a backup on there, and we want to make sure that will is thorough there. This person can't do it. Who's next? Sometimes a will is just giving things to a spouse, but the question is, what's next? If there's no spouse, then what? Sometimes someone's unmarried and they want to keep some assets in the family, but we have to define that. What do they mean by the family? Is it nieces and nephews? Is it to your siblings? If something happens to a sibling, what happens? Does it all go to charity? All of these things don't necessarily happen automatically in the statutes. The default rules don't necessarily do this. We got to get them on paper. So at the minimum, we want to make sure we're doing a will, that we're doing something that's going to override these default rules. There are also wills that can in themselves create trusts, which sounds a little confusing, but what you can do is say, hey, if this money goes to my kids, If they're not 30 or 35 or 20, name an age, if they're not 18, whatever the client wants, then we're going to hold it aside until they turn this age. And in the meantime, there'll be access for education, college, healthcare. We do that for young families a lot. Sometimes with young families, cost is a concern, and they're more likely to lean towards a will plan for now. They'll do their probate skipping estate plan later. So wills can go from being somewhat straightforward to being a little more complex depending on what folks want to accomplish. We've seen quite a bit of it, and regardless of the family's priorities, we will certainly have some examples and some options we can talk through. Whether or not you create your own will is really going to be a function of your own peace of mind. You can always represent yourself in any legal proceeding, any legal matter, and any legal document. You can create your own leases, you can create your own business organization documents, you can create your own prenuptial agreements, you can do your own divorce. The question is, does that bring you the peace of mind that you maybe deserve or want when it comes to your estate plan? Ambiguities, incorrect names, incorrect dates, incorrect execution. These are all things that take what might be a straightforward probate and turn it into a very complex and oftentimes very expensive proceeding. I don't think people place enough value sometimes on what the family is going to have to go through with this document. So for your own sake and for your family's sake, my recommendation is find an attorney who you trust, who you believe will give you that peace of mind. Work with a professional. The attorneys in our office have been working with wills and probate controlling documents and probate avoiding documents since the early 2000s, at least in one form or another. Personally, I've been working with wills and trusts since, I would call it 2008, when I began working as a trust and probate administrator for banks. The collective experience of the group, though, we've seen a whole lot of stuff. It's getting harder, I think, to surprise us, but nonetheless, we get a lot out of helping families through this process. When you call our office about completing a will plan, you're first going to speak with our client services director. And what this person will do is give you an idea. They'll get on the phone with you very quickly, same day, and they are going to outline for you a little bit about our process, a little bit about our costs, give you some options there. It's hard to say specifically what things are going to be, but we do work on a flat fee. So you certainly won't sign a representation agreement and make any payment on anything until you know what it costs. But they'll give you some ideas on that. Once you have that information, if you're comfortable and if the time is right for you to move forward, she's going to connect you with one of our attorneys, and there's going to be an initial planning meeting put on the calendar. This is going to be an hour to an hour and a half. It does not feel like it's that long. It is hyper productive. You're going to get so much done. You're going to learn so much and probably get the whole plan drawn out with your attorney. There'll be some information you need to bring to that meeting. So the attorney's going to want to see, and the client services director will outline this for you. But there's a questionnaire that talks about the important people in your life. Who are your decision makers? Who are the people who share your values, your family members? It'll give a little bit ask a little bit about assets and what you have out there. Much of that can be determined during the meeting, but really do your best on this questionnaire. I would argue it's one of the most important parts of the process. Bring that to the meeting. Like I said, very productive, and they're going to outline for you every step of the process. You'll know when you're going to hear from your lawyer. You'll know when you're going to get documents or document drafts to review. We're going to keep you at the forefront of this process as we get through it. And once you are comfortable with your documents and everything looks good, based on your schedule, we'll bring you back in here, get everything signed, notarized, witnessed. If anything needs to be filed with the county, we'll take care of that for you, and you'll be all set.